Thank you so much all for coming this afternoon, both the spectators, competitors and our judges. Before we get started, I introduce Georgina. I just need to do a quick acknowledgement of the country. I'd like to begin by acknowledging the traditional custodians of the land on which we meet today, the Boonwurrung and Wurundjeri people of the Kulin Nation, and pay my respects to elders past, present and emerging. And now Georgina will do a quick introduction of our judges.
Good afternoon, distinguished guests, supporters, ALSA committee members, ladies and gentlemen. We welcome you to the grand final of the Deakin Law School negotiation competition. Over the past 5 days, we've been seeing amazing competitors from Australia and New Zealand law schools representing both countries. Joining us today, our esteemed judging panel are Professor Jenny Lighthouse, Alice Kiramov, and Christiane van Uveren. Just a little quick introduction. Professor Jenny Lighthouse is currently the Dean of Deakin Law School and the founding partner of Francis Ulrich Lighthouse.
Close.
I'm sorry.
That's okay.
I was like 3 people.
I'm always pleased when people get Lighthouse right. I don't care about the rest.
She's a Melbourne-based technology law firm that's a global frontier for its work in the life sciences, cybersecurity, defence, commercial and intellectual property sectors. Professor Alice Kiramov holds a Master's of Law degree from the University of Melbourne. Since 2013, in addition to his bar practice, Alice has lectured at Deakin University. He has taught predominantly in the law of equity, taxation law and criminal law, and also in contract law, criminal procedure, evidence and sentencing law. Alice has given his time to judge moots and preparing students for international arbitration competitions at Deakin and La Trobe universities. Christiane van Uveren is a Griffith Law University alumni who practices in workplace law. Christiane has been involved in the negotiation competition since 2017, and today will be the third time he is judged on the grand final panel. He has also been considerate enough to volunteer his time this year for the preliminary finals. I thank you all for coming to watch this final. It's been a privilege to be involved in such a high caliber competition, and I'm sure the grand final today will be equally. Please enjoy.
Simply before we get started, we need to go through the basic formalities. Just for purposes of today, we'll go Team 1 and Team 2. Can we please get the party representative for Team 1? And team members, please. By process of elimination, that means you're NC1. And teams.
I'm Djon, DJONTYA.
And I'm Leilani Taula, LGI, LANI. And Taula, TAULA.
Excellent. Both teams familiar with the rules, or do we need another quick refresher?
Given that we have 50 minutes and we're about to start our timer, perhaps Team 1 will start.
So we will have a master clock, but both teams are more than welcome to keep their own time. Do you want to warn before we get things once 5 minutes from now?
1 minute time sheet will do really well. Thank you.
And we have your Team 1, so start.
Thank you very much for meeting us today. Lovely to see you.
Leilani.
And we very much appreciate having you join us today. How is Ainslie?
Now, from what we can gather, this has been a tough time for Ainsley, obviously.
Yes, right.
She's a new mother, and so enjoying that aspect of her life, but the sort of court proceedings and the legal proceedings that we're here to deal with today have, I guess, taken a bit of a toll. She's certainly feeling that alongside the general ties of, I guess, dealing with a newborn and a young child.
Oh, absolutely. Well, she's very stressful with the baby. How's the baby?
We hope that the baby's well, but our client hasn't really talked to us a lot about that.
Oh, okay. Of course. Well, thank you for being with us today. We just want to say that we are confidential, and that this negotiation will be about prejudice to both sides and both parties.
We would also like the negotiations to be about prejudice and rely on that. And yes, we're here to negotiate in good faith, and even if today will be with the utmost confidence. We also have authority to sign full final settlement today. Does your client use that?
No doubt we both prepared gently.
Certainly have. Certainly. I'll pass you my agenda.
Can I just have a quick look at that?
Certainly. Would you like a continue for that?
Very similar in frame, so we would be happy with
Perhaps then, I suppose from our perspective, there are some issues that we definitely need to resolve before we can get on to sort of discussing proposals and
So, what do you have in mind?
so I suppose first and foremost, I guess we want to canvass why we're here today.
Great, thank you.
So our client, Ainsley Wilder, wishes to be a mother, and she wants it all. She wants to be a mother and have a career, and we're here today to help facilitate that dream of hers. We're also here because obviously these legal proceedings have, I guess, taken a toll on Ainsley, and we very much hope to be able to settle this today and move on, and hopefully come to some kind of amicable agreement that both parties would be happy with today.
We appreciate that. Would it help if we, just for the benefit of everybody present, if we just run through the facts as they stand, perhaps just to make sure that we're all on the same page. So, as we understand it, Ms. Wilder has been an employee with Horizon for some time. About a year ago, a little more than a year ago now, 18 months or so, and she got pregnant. She suffered hyperemesis gravidarum. She was hospitalised. There was an alleged incident in the hospital that is in dispute, but relating to her former employer, Jake, who was part of the as a result of that interaction, what had happened, Ms. Wilder has been off work with firstly hyperemesis and then subsequently with stress and anxiety. She's still an employee of our company, our client's company, but on unpaid medical leave today. And at the moment we're looking at having a hearing tomorrow morning, and we're here in an effort to try and avoid that happening for the benefit of both parties. Is that effectively how you see it?
There's one slight thing I'd add. So after the alleged incident in the hospital, there's another alleged event where our client went to speak to Jake, saying that she was going to go to HR, and at that point there was a comment allegedly made by Mr. Stern that was discouraging of that.
Okay,
thanks very much. Yes, right.
I guess I would really like to quickly add as well that our client's main interest is, of course, protecting the public interest and the public image of Horizon, and that most importantly, our employees at Horizon, they come first, and any poor public image would be unbeneficial against our employees. So, I just wanted to make that point clear.
Particularly in light of the brand that Horizon's built, that sort of progressive liberal, engaging women in sort of maternal rights and maternal rights. So we understand
that's
that.
exactly right. Thank you. Yeah.
I suppose some more specific interests on the part of our client. We are really here to safeguard and protect our client's physical and mental well-being of the child. And in light of moving forward into that new chapter of her life as motherhood, we do really hope to secure it's a financial security part. That's a big, concern for our client moving forward, as well as we want to mitigate the emotional impact that this event might have on our client in the future.
Absolutely. So I think. Sorry, you can
Well, you might have some ideas about how that might play out in the image. So
Yes.
So one introductory point is I think you alluded to before that Mr. Stern is no longer a member of Horizon. Is that correct?
we can confirm that. Before we move into those specifics, it might be helpful to you if we perhaps will share our interests as well. So it's all on page. Okay. Okay. So as Ethan alluded to, certainly the profile of the company is important, but very much as Elise, our CEO, has made very clear over the years, the welfare of all the staff is of paramount importance, and the efforts to make it an equitable workplace are not lip service. She generally means it, and this includes ANZ, of course, as well as the other employees. So beyond that.
Now that we've got all of our interests on the table, I think that would be really good to move forward. And Yuri and myself are really happy to listen, and if you had any suggestions or proposals we see here on your agenda, and in terms of employment, role line director and manager, would you like to just discuss a bit, and we'll have to listen to you.
So I suppose our first, the first thing that we need to deal with is really the discussion around Mr. Stern, to confirm, I guess, his place in the company and how the company sort of sees moving forward that relationship.
And naturally that will connect to her emotional well-being with Gary, so she interested in that confronting again. So we can confirm Mr. Stern has left the company. So I think he left when the complaint was made. So we can reassure your client that she wouldn't be in a position where she needed to confront him in the workplace, or should she?
Further to that, I suppose, does Horizon sort of have any other involvement with Mr. Stern
Considering when the CEO of Horizon's early 30s, and considering the close connection with Mr. Stern, it wouldn't be unlikely that they were still in contact to some sort. So, considering they've been business partners for many years, it is extremely likely that they would still be in contact.
Okay.
So that's important for overview as well. But that doesn't mean that Ainsley will be in contact with Mr. Stern.
So what is Mr. Stern's involvement with the company at this present time? Is he sort of completely removed, or is he still a board member, or how does that sort of relationship work?
He's not. He doesn't have a formal connection with the company.
Okay.
He's not his own employee. We gather they're still in touch, the two of us, Mr. Stern and CEO, but we don't want, again, Elise is very careful to make sure that whatever arrangement happens is going to be too comfortable. And so she's keen on it.
That's really good. From what our client knows about Elise, and from what the public generally knows about Elise, is she is known for being routine and wanting to make well-being staff a priority. So that's really good to hear. I guess from our client's perspective, one of the reasons she is really concerned about Mr. Stern is, I suppose, during sort of the proceedings, it sort of seemed like there was a dispute between two employees of Horizon, and Horizon has appeared to, I guess, fall down on the side of Mr. Stern rather than Ainsley. And so, from her perspective, I guess, she really doesn't want any suggestion that, I guess, Horizon is condoning the alleged behaviour. And that's, I guess, a part of it as well. It's not, I suppose for her, it's not just the prospect of directly confronting him in the workplace, but, that idea that she doesn't think that, as she perceives it, the events happened, she doesn't believe that to be okay.
Absolutely. I think it's really important for Yuri and I to acknowledge that there has been some lack of communication since the alleged incident, and we absolutely do acknowledge that, and we're happy you brought that up, so we could just bring that to the table as well.
You understand, from what it sounds like you're saying, Ainsley would like to avoid even the perception of bias. Does that sound fair?
Maybe not biased is quite the right word. Maybe that sort of idea that horizon side is what is discerned.
Yes.
Maybe it's not biasing anything going forward, but sort of maybe improved and past that actor in favour of him rather than him.
Would a formal statement to the contrary help? Would it be helpful to Ms. Wilder if we made a statement, perhaps regretting the manner in which we conducted ourselves? Because we do recognise that what we've done, the manner in which things have progressed so far has been perhaps
Yeah, I think from our client's perspective that would go a long way. I think that that sort of show of support, I guess, to a more formal open show of support would be really lovely.
What do you think? What kind of formal statement do you think? We can discuss this later. Maybe when we're both on the break later on, and we can discuss that formal statement.
I think that's probably for the best.
Yeah, let's move forward.
Just one more question about Mr. Stern.
Yeah.
I don't want to keep dragging it down.
That's okay.
You said he left very close in time to the sort of alleged events. Can you shed any light on what happened there?
It was actually completely unrelated to the events. So we're aware that he had other opportunities, and he's now doing some other work.
I'm really sorry to hear about that as well, because from what I understand, he actually did contribute a lot of value to the company.
Yeah, he did.
But I guess from our client's perspective, that resolves that issue quite nicely. So I guess if you're happy to move on to sort of discussing potential terms of employment.
Yeah, absolutely. So we're happy to just listen to you for a moment if you wanted to give us any ideas that you had. Then Yuri and I are happy to provide some options that we think are set in stone.
Okay.
If you want, we can provide the options with you up front.
Okay, that would actually be very helpful.
So I'll just pass you this document here.
Thank you.
We can run that through for
Or
you.
through it.
So option A was a personal assistant full-time role. So Ainsley would return to work as a personal assistant with senior management. And that would be at a salary of $45,000 and full-time Monday to Friday. However, we did have another option, a personal assistant part-time. So it's actually the same salary there. We'll be happy to pay 2 to 3 days per week. However, when Ainsley is, she will need to remain on call out of hours during her working days. And that would also mean that she would have to attend a meeting every second Saturday to hand over relevant information to the others sharing the role with her. Do you have anything to add?
Well, just that we recognise, given Ainsley's situation with her child, that second option, given that it's not terribly flexible, might not be all that attractive. So that it's there as an option.
Correct. I suppose you've already sort of preemptively guessed at some of the things that our client might struggle with. She is obviously a new mother, and there is a lot of sort of things that she's trying to discover about that new aspect of her life. And so she would. We have been instructed that we definitely need quite a flexible arrangement, and so we too have, I suppose, some more specific set in stone terms that terms we should elucidate for you.
Sure, we're happy to listen. If you can hand them over to us, we'll take some notes.
So the first thing was sort of she wanted to be on at least the same salary she was on before she went on maternity leave or before she left because of the incident. That's not non-negotiable for our client. She also wants to have just discretion over the days of the week she works, and she doesn't want to work more than 3 days a week in the foreseeable future.
3 days a week. So that the salary would be prorated.
As far as we are aware, that wasn't what she had anticipated. So perhaps what she maybe had anticipated was having some kind of flexible arrangement that she was able to sort of fulfill her obligations in those 3 days in that 3 day period.
In different days, or within the 3 day period.
within days.
So like Monday to Wednesday, or maybe like Monday, Wednesday, Friday, or changing multiple weeks.
So yeah, I think the intention would be that it would be changing week to week. So it would be
Okay.
a set Monday, Tuesday, Wednesday, but only 3 days and only during the week.
No, that's absolutely understandable. Did you have any other points to add?
So she sort of wanted to be able to transition back into the full-time workforce at the point that she decided that she was ready for that, and she wanted to have full discretion over sort of when that decision, when she felt that she had taken care of her baby to the stage that she was comfortable sending it to early childhood education or something similar. So she wants the sort of full discretion to decide at what point she would transition back into a more full-time role.
That's certainly reasonable. We
Yes.
That's good. One other thing is, as I'm sure you're aware, which is why Ainsley was, in the second option, it was you wanted Ainsley to be on call. That was, I suppose, part of her role previously, prior to having a child. But yes, she, in
Considering
the
child,
changing situation, that's not something that she was open to at all. So
Right.
the idea of being on call for her is somewhat not negotiable either.
So that they were all the points that Ainsley wants to be able to reach. Yes. Okay. I'm sure you can understand some difficulties, especially regarding different days throughout the week, because we do have an ton of employees to keep happy, and if there is seen some favoritism towards Ainsley. However, considering some of the recent initiatives, is something definitely that Yuri and I will discuss on the break and come back, and then we could give you some more specifics. But I think Yuri and I had a really exciting opportunity for Ainsley that we'd really like to discuss with you today. I might actually hand over to Yuri to discuss this point. Are you happy with that, Yuri?
Nathan, actually, just before we do move on to
Yeah.
that point, I'd like to just make sure I've nailed those specifics of what Ainsley's looking for. So the previous salary that she's keen to return to, what is that?
So she was previously on $65,000.
Right, you're looking at 65.
Yeah, at least. And sort of the role that she was looking to come back into was the one that she left. So I believe she was working for an executive member of staff. And I see that you said senior management. That may be just a semantic argument there, but she had specifically used the term executive. That's the role that she has wanted to sort of go back into again. And again, with the scheduler flexibility, she's not able to work weekends, she's not able to be on call, and she would like to have full discretion around what days she is able to work, and it's absolutely only 3 days.
I would like to make a small clarification, if that's okay, regarding senior management and executive role. The senior management is actually one level lower than the executive.
Oh, okay.
Which is why there was a dip, which is why the salary is lower.
Oh, I
There
see.
is one of the things that's probably worth making fairly clear about the salary as was, had a couple of bonus elements. So the fact of being on call and having extra duties gave her $5,000 addition on the $55,000 base salary which she in fact was entitled to. And then there was an additional $5,000 that was paid to her out of Jake's salary. So the $65,000 was in fact $55 plus a couple of additional elements made from having additional duty and from her manager who obviously valued very much. So that additional duty is $5,000. If she's unable to retire, we couldn't offer that additional.
What about if there's potential for her to add value to your company in another way?
Yes, there may be. I think that's what Ethan was alluding to.
So recently, she's been approached, sort of, in light of the stuff that your company's done in the workforce, sort of promoting the idea of the flexibility and sort of being renowned as a great company to work for in sort of the pregnancy time.
Yes.
A company's approached her, a TV company, to try to make a TV show that would talk about her sort of reintegration back into the workforce and how Horizon has gone above and beyond in facilitating that. And so we think there'd be a real opportunity, maybe to show how Horizon has been just an exemplary employer in that regard. To some extent, obviously, if us looked in doing some peripheral research today and found that sort of a primetime slot in Australian television for like a 30-second ad is worth $20,000. So obviously we're not asking for anything in that ballpark, but if this was to be sort of at least even 6 episodes of reasonably primetime television, that is a whole lot of benefit that your company is getting to promote the values that it really cares about, to promote what Eliza is passionate about Elise. And so we think there's like a real opportunity there. And so in light of that, I think there's an opportunity. So for, obviously she'll be focusing as a personal assistant, but she'll be adding value in ways that every other secretary does, the company doesn't. She'll be being able to spread the brand message, spread everything the company cares about. So would that be an option in light of that?
That is extremely exciting. I would love to discuss this with Yuri in private shortly and come back to you and really discuss more, because we are making very good time, it seems. But that is something we're extremely excited about, so thank you for bringing that to the table. So Ainsley is very much looking to come back to Horizon, work with Horizon, and still give Horizon the good light that we've always had.
I suppose our client has told us that she still views Horizon very favourably, even in spite of all of sort of the bad blood potentially that might have arisen. Ainsley, she has friends at work, and she understands to some degree, I guess, why things happened the way that they happened, but she doesn't place blame, I suppose, on Horizon. That's solely something that she feels towards Jack, Mr. Stern, I should say. And so she's really willing to come back on board and, I guess, promote the values that she herself is living out at the moment.
Absolutely.
We really hoped that this would form some of the solution somehow as well. We had our own ideas. Naturally, Elise is very keen to embody those ideals, and we thought it would be wonderful if we could use our 2019 Pregnancy and New Family Initiative as a way of bringing Ainsley back into the fold and resolving the disappointment she's felt. We're really excited to hear about the TV show, and there's a fabulous possibility. It might work in well with the salary negotiations, and again, we can hash that out now, perhaps. But we had another proposal that we might run by you, and that is that rather than as a salaried employee, Ainsley naturally needs flexibility in her life right now. She can't know when she's going to be at work, at least for the next couple of years until her child's in kindergarten. And so for that time, we would like to know what her experience of new motherhood and returning to work is like, so that she can consult to us, or to our client, I should say, in that regard.
I think that's a really, really lovely idea, and I can definitely see Elise's values sort of coming into this.
Exactly.
We have some initial numbers which we could run by you. I think we've left them right there. Effectively what we were looking at was a retainer, our annual retainer, and then a certain number of guaranteed consultative hours per year for, say, the following 2 years, so that she's in a secure financial base until perhaps it's either time to return to work, or she might prefer to continue as a consultant.
I think it'd be a good idea to give us the numbers that you may be prepared to offer. I think this is quite far outside the scope of sort of what we've come to negotiate today. She was sort of under the impression that we'd be negotiating for her to go back to her role. And so, given that we've got full authority to sign, I still think it would be improper to maybe sign her up for a job that I'm sure maybe she'd love, maybe she'd hate. So I think on that point, while we're happy and excited to take this maybe back to her, I don't think we'd be able to sign on that today.
I do completely understand that. However, this job is the job that will meet all of the requirements that you set out, all of them. The requirements that were set out, that's very difficult for us to maintain at the Horizon headquarters. So we would really, on the break, we would really like you to just have a look over the consultancy agreement there, so we can come back and have a look. Because I think Ainsley would love this, and Yuri and I are more than happy to add a clause that if she doesn't want to do it, if she doesn't agree with it, we can organise something else. But we really do believe that this is perfect for Ainsley.
I agree. I think that despite the fact that this is not something that she had anticipated, I think that this could meet all of the requirements that that we've laid out today. I do think the idea of pushing in a clause, obviously, that should be immediate, that it doesn't work out. I think that would be a good idea. I also think perhaps is the reason, I suppose, why this consultancy agreement has been presented today, because it's a way for Ainsley to add value to the company. and I guess sort of allow the company to gain insight into how they might carry on this pregnancy and new family.
That's exactly right. That's exactly right. Considering she has just had a baby, we are looking at future initiatives in the future. We have no guarantees on the future initiatives, but considering we had the paternity leave and maternity leave in the pregnancy, we're very much expecting maybe a family initiative to come up soon, and Ainsley fits that role perfectly. So her job would essentially be to give us feedback and consult with us regarding the family, bringing up a family.
It would be helpful to repair a relationship too.
Certainly. I suppose we, at the point where we take a break,
Yes.
which I hopefully will be
No, absolutely.
my partner and I will look over this agreement.
Yes.
And then also, we'd love to hear, I guess, at the end of that break, your thoughts on potentially working with our client in relation to sort of more of a, I guess maybe a media-facing type role. I think, in light of the fact that this story could be painted quite terribly, and in fact that's not what Ainsley wants. She wants to come back to work. She wants to, I guess, have her place of work be something that she can take pride in. She can, I guess, work in a role where, although it could have been negative, she could turn around and say, no, I was really well supported. This thing happened, wasn't good, but this company has stepped up and has, I guess, made this whole process so much better for me. And I think there's a real opportunity there that if you would consider
No,
it.
absolutely. I think that's something Yuri and I are trying to do with the consultancy agreement. But maybe there'll be some changes, maybe some switches that we'll need to agree on after the break. But if you're happy to go now, Yuri and I might happy to go now as well. We have 5 minutes.
Great.
Okay.
Actually, there's probably a couple of things. I'm so sorry to pull you back, but a couple of the numbers. Djon, your point is well made about this is different to what we had in between, so we respect that. So the numbers that we had in mind were an annual retainer of say 20,000, and then an hourly rate of say $80 an hour with a guaranteed 500 hours guaranteed per year. So that would add up to 60,000 guaranteed for the first year. And so that's the kind of thing that we'd be looking at, but that would be a minimum number of hours. So it would depend on the consultancy. The nice flexible thing about a consultancy too is if she wanted to move into media related work, well, that's available to her too, because we're not constrained by a job description. And we recognise also her media skills, because a lot of what Mr. Stern was able to achieve was thanks to her.
Exactly.
We really want those skills to be put to use.
a great man, right?
Well, yes, but so that's important to know. Something else that's very important to let you know, just for you, because you were asking about the executive PA roles versus the senior manager. At the moment, the executive PA roles are filled, and we recognise that's where she was. But at the moment, what we're able to offer right now is a senior manager PA. If she wanted to move back into being a PA, we might be able to look at when the executive PA role became isn't about the one. There's more to be done.
Could I just make a suggestion before, and then perhaps we can take over it?
Absolutely.
In relation to this sort of private consulting role, just like that it is, it is outside the scope of what we will essentially negotiate today. Perhaps, in light of the fact that this really is something that is close to us, at least, it's really something that she is quite focused on. Perhaps it would be, you might be open to the idea of saying that Elise was, for example, the person that Ainsley directly reported to. So that, the person who's really the most invested in this is the one who's getting the information first.
That's very much our intentions as well.
Indeed.
So, although perhaps, this wouldn't necessarily be considered, an assistant role, as a personal assistant role, maybe we could consider having, a private consulting role whereby she reports directly to Elise.
Absolutely.
Yes, that's a great point, and thanks for bringing it up.
Right. Well, in light of that, shall we take a short break and
Shall we?
discuss all of these
Thank you.
options? Thank you. I have 20, half an hour, so we'll come back at 35.
Yes. Did you find a copy? Still don't know how to use it. It's the most complicated machine I've ever seen.
So first of all, thank you so much for hearing this proposal for us and looking over it and hopefully just about agreement with the agreement. So I suppose something that my partner and I discussed while we were outside and on that break is one of the things that was important to our client, which I suppose I didn't articulate as the roles on the table seemed to be in line with that, was that she would go back into a personal assistant role. One of the reasons obviously being that she's done this role before, it's not shocking to her, it's not something that she's going to have to try and learn while she's already trying to learn how to deal with her new role and motherhood. However, we do think that we could, that this could be potentially a palatable agreement to her, but we would need to have some significantly higher guaranteed hours per year.
So I think our client would be on the more palatable and more likely to agree with. If it's a consultancy would be reviewed at the end of 2 years, the consultancy may be absolutely review probably on her asking. And also if any sort of those senior executive roles were to come available, that she'd be the first candidate, sort of asked if she wanted to do them, and then if she said no, obviously you guys look at other candidates, but she'd sort of like the first right of refusal to any senior executive roles that came up.
That's sensible. It would be perhaps good protection for both of our clients if we did nominate a review time. We're keen to find out what you think is real. We did put 2 years, but we're happy to hear from you. We think it's probably best not to leave open-ended. What would be sensible?
So if our client does have that first right of refusal for any executive PA roles that come up, I think that, do you reckon 2 years is a workable number?
2 years is a workable number.
With the option to return to work if something comes up.
Yeah, exactly. Or first right of refusal. Maybe it's
Certainly, that's good.
I might add as well, considering that she does still have a young baby, Yuri and I were thinking, right, that's why the hours are quite low and the hourly rate is quite high. What we can add for you is maybe a $10,000 sign-on bonus. So that would actually increase the total work to $70,000.
I guess the slight fear about that would be obviously a baby's expensive in year one, but it's also pretty substantial costs in year two for a baby. And so I think that in order to fully support him and fully live up to those values that enterprise embodies, I think having that be recognised in the salary would probably be more adequate because it would allow her to make plans not only for this year but for also the future. So I think that would allow her that flexibility.
So she's got a baby on the way, sorry? Is that what you said?
So, sorry,
Sorry.
what we're saying is that the child is here this year and will also be here next year. So, yes, we hope. Yeah, we hope
Then,
so.
what would be sensible? Would you like to make a counter proposal?
So we were going to suggest 700 hours per year minimum guaranteed. Also, that would be more sort of towards the part-time as opposed to 500, which is only a quarter of the working hours in the year. So again, more towards that working half time.
That is fine as far as we're concerned, I think. We can
In favour rather than signing on bonus. So it reflects in the salary.
I suppose for our client it just helps because at some point potentially, in the distant future when she's maybe looking around for other kinds of jobs, she'll be able to point at, the salary that she has and say, my company that I really respected and loved valued me this much, which would be nice for her in the future if she chooses to go into public.
She's not currently looking for any
No.
Absolutely
She's
not.
very much meant to rise, but 20 years things change.
No, of course. That's why Yuri and I thought this consultancy agreement was quite amazing because it gave a really quick progression.
Yes.
And while she's working with us, she does have the opportunity to work with other people as well. And that's why this TV offer as well is absolutely amazing. So we can add this in here.
I suppose we do understand why the consultancy agreement is obviously it does meet all of those sort of on paper terms.
Exactly.
But to our client, there is that sort of external stuff of the fact that it's not the job that she left. Potentially she won't be working with or even close to the people who she considers her friends, which is part of the reason why she wants to come back. So even though for the interest that we articulated, yes, you're right. This is something that I think that if our client had seen, perhaps she would have given us further instructions on that. But it is outside the scope of what we had come to negotiate today. But again, we think that if we sort of make this, I guess, a bit of a sweeter deal as such, it will be palatable.
So we think this deal we've come to today is something we'll take to her, and I think she may be likely to accept it. I wouldn't want to speak to her intent, but I think this is something really good we've come to together. In regards to the TV sort of deal that we were talking about before, would Horizon be willing to offer any additional incentive? Because obviously Horizon gets to get shown in a fantastic light, and all those characteristics that Horizon embodies are going to be able to be shown publicly on the news, or not on the news, but on TV, and that's going to be really good and create really good press for Horizon.
Great. How long would the do you know how long the production schedule would be? Is it a sort of 6-month process?
So it's
how many episodes?
all it's described as a reality TV show, so we don't have a particular.
Follow her around through the office with cameras and things. We're more than willing to make the office available to crews and provide hospitality to crews, that sort of thing. But beyond that, you have something in mind, something tangible.
So I suppose perhaps we could agree to some kind of arrangement where we calculate sort of the value of the screen time. So what was the number that you said?
And this isn't necessarily sort of an indication of what we're going for, but just sort of to put it into perspective, the amount that a prime time slot goes from Channel 7 is $20,000, only for 30 seconds. So obviously the content could be exceeding the large, and that's not what we're asking for. We're asking for an amount that we consider far more reasonable in light of watch sort of the value of overall advertising that we feel that Horizon is going to get from the deal. So we're going to suggest in the region of $20,000, which is obviously only 30 seconds of screen time for that sort of prime time TV.
And also, another thing that we think is beneficial, and maybe our interests sort of align on this point, is that it really gives Horizon, I think, the opportunity to be involved in the story as it is told. So, the fact that Horizon is Ainsley's coming back to work, and obviously this consultancy agreement is something that is super flexible and speaks to all of those values that we outlined earlier that are important to Horizon. But I think being able to say, publicise that and potentially be in control of the story a little bit is really beneficial to Horizon as well.
So,
Do you have anything on paper that we could have a look at regarding the TV issue, just so we can go No, that's okay.
what we might have to do in the interest of time, I recognise we are running a little short on time. Something I wish that I would like to have brought up just a little earlier was the instructions we have regarding an agreement to a deed of settlement that would be related to Ainsley's return to the company. Again, it's something that I think would not be an issue, but we are instructed that if Ainsley's return to the company in any capacity, that we would have an agreement, for example, on non-disclosure relating to the dispute and so on. We hope you won't have an issue with it. I want to bring it up now.
Thank you very much. This, I suppose, is very efficient. Very glad to read through. I think, on a quick look at it, I think something that I should make clear is that Ainsley is obviously wants to have the opportunity at some point potentially to tell the story. Regarding Mr. Stern. And so we wouldn't want to sign anything on her behalf that would limit her from discussing potentially Mr. Stern. However,
Based on the wording of this, I can see that it doesn't mention former directors at all. It only specifically refers to directors. Sort of, and if that's to be read, sort of, I don't know, this almost inviting it to be a prejudice statement, but if that's to be read to directors from this point onwards, I think that is something that could be palatable for our client.
Perhaps what we could do is put a time limitation on it, that the dispute not be mentioned for a number of years. Perhaps that would be a good compromise. So
as from my read of this,
yes.
And this is the only reason I brought up the Mr. Stern point was because I think that we should make utmost very clear sort of our client's interest. But on reading this document, there is nothing. I think our client would be happy to agree that she would not disparage Horizon, that she would not disparage any of its current employees.
Or its directors,
or its directors,
or its executives, or its owners. So I actually think
But we hear what you're saying too, that she wants to be able to speak.
In light of the fact as well that you seemed somewhat receptive to the idea of media coming into the office and looking at how Horizon is taking steps forward, we think that in order to make that story make any kind of sense, I think we do need to, there does need to be sort of that starting point, which is, something bad happened and then Horizon has swooped in and done more than it needs to be able to overcome that burden.
Horizon is the hero in this narrative. They've gone not just to the where what's maybe required, but they've gone above and beyond. And so I think part of that sort of telling that story would not disparage Horizon, it would in fact make them stand on a high mountain and be like
No, of course.
a paragon
So,
virtue.
in light of that, and the way that this document reads, I think that we can definitely sign on behalf of our client.
No, absolutely. I might just add, the reason it is important for us to add a time limitation on this is because you know how the media can be. Whilst it sounds very nice for us to come in and save the day and really show what we do, the problem is the media doesn't always show the truth. And our problem is if there were to be bad personal and professional effects to our employees and their families because of the media, that's why we will need a time limitation. It's quite important to us and our employees.
And that's completely acceptable
Perfect.
to us. I suppose just to clarify again, our client, by our reading of this document, our client would not be disparaging or breaching the agreement if she were to speak favourably of Horizon. And as such, the dispute between, for example, herself and Mr. Stern, which seems to fall outside of the purview of this document, and in light of that, we would be happy to sign this agreement on behalf of our client. But what I'm gathering is that you're trying to suggest that conflict is not discussed at all for 2 years, for example. But as far as I read this document, that's not necessarily how it reads in black and white.
I think we see what you're saying. I think in the interest of time, we would proceed on the understanding.
Okay, thank you. Would it be worthwhile now, in the sort of last few minutes that we have to run through what we're agreeing to today?
Yes, thanks.
I might pass this over to you here, and I can really quickly run through everything that we've discussed.
Okay.
So we're agreeing that the negotiations are confidential at the beginning, and that includes statements made by either party, outcomes of the agreements made as a result of this negotiation. This will need to, of course, be edited because we, whilst we won't discuss the negotiation, of course, with the TV and what Horizon has done, we will edit this slightly for the future. We will discuss that. Any statements made during these negotiations, of course, without prejudice to the rights of either party, and we'll
Just on that point, I would like those comments, if you accept it, I'd like those comments about Mr. Stern to be with prejudice. I'd like them to be able to sort of inform the interpretation of the contract at any later point if that was to come up into the argument in a formal body. So would you be okay with if just specifically the comment about Mr. Shaw not being, Mr. Stern being included in the current directors, would you be okay with that? Sorry. I see what you're saying. Yes.
We just want to be assured that Mr. Stern is in fact a director.
Understood. Yes, we can say that.
Yeah, we can accept that, absolutely. And just moving down straight to point C, point A and B will skip completely there. So she will be the independent consultant of Horizon, according to the terms outlined in Annex B that we have provided with you. And this agreement is on the deed of the settlement that we have just discussed as well. She will report directly to Elise. We have agreed to the TV show, and I think the discussion of additional money payments regarding the TV show will need to be discussed further in the future. But that is absolutely something we very much look forward to. And also we will like to add a formal statement of regret as well.
Excellent. And just for the specific numbers that we've agreed on, we have 700 guaranteed hours per year with a 20k annual retainer, which and that will amount to the salary.
Perfect. And on the back as well, it's just the cessation of future action as well. Oh, my apologies.
Thank you.
Well, it's time to start. Thank you.
Thank
both
you.
very much.
And that's time.
Thank you very much.
Thanks so very much. Pleasure. Thanks.
Cheers.
Yeah.
Thank you.
My understanding is both teams now have 2 minutes. Where you keep your time questions. You go first and the second.
Thank
Is it okay if we start the time as we move before?
I heard you want to practice the copy machine, now's your moment.
So both teams are aware, we'll figure out who's going first, who's going second. The team who's going second will separate outside so no one's got an unfair advantage. You've not the 2 prescribed questions, both teams should be aware of that. The panel can either ask you those questions and correspond whilst you can ask you those questions, you can talk between yourselves. If you've got a different way of going about it that touches on one or 2 questions on the way, that's more than fine as well. Simply let us know what you're most comfortable with. We'll give you another minute warning before you get in the 15 minutes, and then that will conclude time. Very possibly during that time, as we may have some questions for you, we will try and not interrupt you in seconds to train.
Do the kids. Full kids different time.
Okay.
It's gotta be this time.
His heads.
Who'd like to go second?
I'll ask you the questions to respond. I'll ask you the questions to talk between yourself. What's your preferred method of approach?
We enjoy running through the criteria, positive and negative, and looking at questions as it relates to each criteria. And go through that.
We'll try and leave some time for some questions at the end if you do have any questions at the end.
You guys will let you with it. Otherwise, feel free to
So, Ethan, preparation.
Look, I'm very happy. We always seem to be the most prepared team. That's something we try to really do in regards to the documents. It really helps with the understanding. We can hand over a document and explain it, and I'm really happy that we're able to do that again today. As it really works in our favour, and it works in the other team's favour as well. It just shows good negotiating.
It does really help the conduct of the day, of the negotiation. We don't need to write all that stuff down. A lot of it's anticipated. A lot of the solutions, a bit less so in this case, but a lot of the times we're able to anticipate the likely solutions, and it saves a lot of time.
And I guess that where adaptability comes in, we're less likely to anticipate the solution. We were able to anticipate her needs, and I think we were adaptable in having all of her needs met, especially in regards to the consultancy role. And so I was very happy with that. Do you have any other thoughts on that?
Adaptability wise, I think that's true. We could have spent more time exploring the nature of the TV show engagement when that came up, because again that was ultimately for us, and we could have asked, well, how much will that affect her working ability, her capability to do the job that she was engaged with us?
Yeah, exactly. I agree. I agree completely.
Coming just sort of around back to our strategy, we came in with a clear collaborative strategy, so did the other team, and that was, again, it was probably expected for a problem like this. We wanted to be conciliatory with respect to our behaviour prior to today. But we wanted to stop short of a formal apology.
And I might add as well, when we were walking here today, we discussed and we really want to listen. And our aim is not to control this negotiation. Our aim is to listen and to act. And I do think the next time we maybe listen slightly too much, because I felt that I wanted to say something, but I just kept getting words, and I hesitated. It difficult at the time, if that makes sense. Would you agree with that?
It's tricky, isn't it? You want to allow somebody to finish speaking, but you're conscious of the time. It's true.
So yeah, I think it was good that we didn't want to control this negotiation in regards to talking. and we've taken that approach in the past, but I'm really happy with what we did today. Considering the aggrieved party, it's good to listen and let them talk.
Right. Speaking of allowing the other parties to talk, tell me about the relationship that we had with Leilani.
I think the relationship was great, especially at the beginning, the discussion, the baby, how you've been,
Right.
mid coming back in, family machine. Just little things like that, just to show that you're friendly, you're comfortable. You hear not necessarily lawyer versus lawyer, but lawyer and lawyer coming to an agreement. And essentially that. Do you have anything to add?
I agree. No, we were very collegial the whole way through. We used their first names, we used the first name of the party. So we really tried to keep the formality, at minimum, which helped the relationship. I think that was good as well.
On that
We
point,
reflect.
sorry. On that point, what were you thinking like our team were?
Right, well, it's usually pretty strong. We're able to pass off to one another. We check in with each other. How is that okay with you, Ethan? We don't like to barrel over one another or contradict one another. We know how that's always a no. So I feel that was strong.
I would like to add one error on my behalf. I did say that Yuri and I are ready for a break, where usually I'll go and I'll clarify something. I'll say, Yuri, is there anything you'd like to add? And I did jump to the break slightly too early, and that was my fault. But you adapted and you said 1 second actually to add something. But that's completely my fault, my error.
There was a lot of things in the air, a lot of balls in the air. Speaking of a lot of balls in the air, the outcome was fairly complex in the end. It had different moving parts. We had the consultancy, we had the option to return to work as a PA, we had the agreement that we had our undertaking that Mrs. Stewart was the company, we had the statement of regret. So there's a lot of parts to it.
But we did have both teams have to be adaptable to different scenarios, and I think both teams did very well in that respect. I'm very happy that we were able to adapt to the needs that she needed and adapt to the numbers and be able to provide numbers and really be concise, time limits, numbers. So we're going away with a contract that actually makes sense and it means something moving forward.
Can I just interrupt you? Can I just ask you, this issue with Horizon still having a connection with its former executive, how did you plan to grapple with that? Because I could see that at the start of the negotiation you quite accurately said that he's no longer with Horizon. Perhaps it's a bit misleading, perhaps not, I don't know, but it's certainly not false. But then there was a point at which you said, but he no longer has a formal, I can't remember who said it, doesn't matter, but he no longer has a formal connection with Horizon. And given that, I mean, sort of discussed at the start, it cropped up again later, did you have any concern that making that representation might, I don't know, jeopardize the settlement?
Look, Yuri and I both discussed it. I was very clear mid-discussion that there is still connection with the lease because they have been business partners for a long time. And we talked about this quite a bit, didn't we, Yuri? Did you want to add anything?
Certainly. That was a really difficult problem because we were under strict instructions not to allow that to come out. And yet we knew they were going to us as well. I think it was me who said he doesn't have a formal connection with the company. I think it was this. So that's a concern. I think the moment I said it. What we tried to do was skirt the issue by saying he's employed by the company, and that naturally he would have connections still with his friend, but we didn't want to go further than that. So yes, that would be a concern in terms of if they were to take that literally and to determine otherwise that.
Can I just ask, as you perceive the arrangement, and I know that some things were a bit open-ended as they would be, but as you perceive the arrangement, how much would your client be paying in dollar terms, assuming that she used her maximum hours? And it's a genuine question as well, because I haven't
Right.
so 20 plus.
Our financial calculations were based on the fact that we had a sort of a war chest, as it were, up front, but also that we had more flexibility with the salary if we weren't moving it back into the PA role. something of the order of 70,000.
Am I right in saying
I believe it's exactly
20,000?
70,000. The 20,000 is actually our sweetener, the sign-on bonus was taken off. They would rather that was reflected in the salary, so we took off the sweetener bonus and actually bumped up the salary. Bumped up the hours, I believe it was. Bumped up the hours, not the salary. So the salary was $80 per hour, and I think the hours were, was it 700 hours?
700 hours, so 700 hours multiplied by 80
Plus
56 plus 76,000.
And that 20 is that in relation to the TV deal, or is that just the retainer?
That was the retainer.
Oh, right.
So we didn't agree to pay.
Oh, the retainer money.
Yeah.
That was, again, we ran out of time as far as the outcomes for the TV deals. They were asking for money for it. We wouldn't have, I don't think
We did say we would discuss that in future, but it's definitely something we're able to arrange.
Can I ask about the TV deal? What exactly is it? And I appreciate you acknowledged before that it's obviously something you want to explore, but what did you perceive, bearing in mind that the TV network is not a party to this negotiation and would not be a party to the settlement agreement, what exactly did you perceive would be promise in the settlement agreement in relation to that? I mean, what is she promising to do? What are you promising to do?
Well, they made it quite clear that it wouldn't be any negative images in regards to this TV deal on Horizon, and we took that in good faith.
But what I mean is, what are you paying $20,000 for?
Right, our perception.
$20,000 today.
No, I understand, but suppose the TV said, actually, we don't want to run the series. Well, are you still having to pay over the $20,000?
Our perception was that we were agreeing to allow
Future discussion.
her to independently work on the TVs. That we didn't anticipate engaging with the TV network ourselves. So we saw it as, we're happy for you to go ahead and do it.
Yeah, I'm not sure what
It's obviously something you need to explore more, but that's not much.
Yeah, I'm definitely on the same page as you in regards to that question. If I had no interpretation of us going straight to the TV deal, I saw it as a separate thing, and then looking for some additional bonus money. I did not interpret it as in we're going straight to the TV deal and paying for that TV deal.
I might say just for the last second or so that we really nailed our interests. The protection of the workforce and so forth.
Thank you very much.
Thank you.
Thank you.
As we said earlier, we can ask you the questions in response to us. We can ask you questions. You can talk amongst yourselves. We can involve how you most.
So then for example, you ask us questions.
Perfect. We'll give you a 1 minute warning. As we said, and feel free to take your own time. I believe the first question is if you're faced with the same scenario tomorrow, knowing what we're doing now, what would you give us and what would you do differently?
So I think one of the things that we struggle with a little bit is that obviously the other team have prepared a lot of the documents and the fact that they came with something that was completely sort of outside the scope of what our client had instructed us on essentially did throw us a little bit in that negotiation. And I think that they did sort of sense that and sort of able to pounce a little bit at perceived weakness on the side of the table. Another thing that I think we struggled with a little bit in light of the fact that our client really wanted to settle the agreement today was that we did run quite short of time. And so that could have potentially jeopardised our client's primary interest, which was not to court at night, not tomorrow morning.
I think one thing we did well was I think we did a good job of leveraging sort of the values that Horizon had exuded to the public, sort of that idea of being really friendly to mothers and fathers and new mothers and fathers in particular. So I think we did a good job of being using those values to sort of drive towards the kind of result that we wanted. So I think we did that quite well.
And I think a lot of the time, the fact that we were able to leverage on sort of the shared values and interests meant that we didn't have to leverage quite so much on sort of concessions. We didn't really have to do too much of the toing and froing about, oh no, you give me this, I'll give you that, because we were able to sort of find that common ground of we actually do both really like this company and we do want it to be perceived well, and especially in light of the fact that ANZ wants to continue working there. And so I think that was something that we were able to get sort of a lot more out of the deal than if we'd tried to do this more adversarial type of negotiating.
I think the rapport across the table was good. I think that we had good relationships with them, and that sort of there was more of a free flow of information. So that we didn't reveal anything that we weren't allowed to, but we revealed, and I felt like they revealed a lot of stuff that was conducive to helping develop a good contract between the two parties. So I think that was done well.
I think one other thing that I think we did well was in light of the sort of we got quite a big block of text sort of handed to us in the last brief sort of minutes of the negotiation. I think clarifying up front that we did not want to disparage Horizon, but that our client did in fact want to disparage Mr. Stern was a really good thing to get out there. And also in light of the fact that they had assured us that Mr. Stern did work for the company, I think that Djon's comment about the without prejudice not applying to that part of this discussion, that if we did find out at a later date that Mr. Stern did work for the company, we would be able to use that in the
I think we sort of protected her as well on that point. Obviously, she quite likes Horizon. She thinks they're a good employee. She understands to a point the position that they were required to take, but she didn't. She had no animosity towards them. So I think we protected her ability to sort of say what she wanted to say about Mr. Shaw, but also not. She didn't have a desire to criticise Horizon, and so I think we got both of those things.
And Laura, do you have any questions specifically about this?
Were you satisfied that the outcome about Mr. Stern, that you thought that your client would still be able to speak about him?
I felt like I think probably one of the important things to them was to have the NDA decide that. I think so that time pressure crunch that was happening to them meant that we sort of were able to get through the discern that Mr. Stern was able to get this parish, and sort of although it wasn't formally incorporated into the contract, those comments were able to sort of shape how the contract would be interpreted in light of the sort of surrounding context of the negotiation. And so I think to an extent that would offer legal protection to her if she was to disparage him. I think to some regard that could have been done more cleanly if we formally incorporated it into the contract. But I think in light of the discussion and in light of the wording of the document, I think that it probably is sufficiently clear that any comments about Mr. Shaw wouldn't be breached and Mr. Stern wouldn't be breaching the deed. I do, however, worry that obviously she actually quite liked Horizon, and so having to sort of take that point and litigate in court because it's obviously a contractual vaguity probably isn't particularly conducive to that relationship. But I suspect, given that they were pretty keen to include that maybe their sort of feelings Mr. Shaw in recent times have diminished maybe. I don't know that it was like in the negotiation, but it seems like they just really want the NDA and were willing to get up that point to do.
The NDA in relation to Horizon.
Yeah, so they're really criticising it.
I also think that in light of the fact that they were happy to have sort of the whole issue discussed in relation to the reality TV show, and they agreed that they wanted to sort of participate in that and help shape the story around that. That goes without saying that at least in terms of that coverage of the media, this would come up, and they agreed that that would be acceptable. So at the very least, our client would be able to discuss her side of the story as far as Mr. Stern is concerned in that regard.
It's not one of the reasons why, because my question was going to be, why does it concern you so much that you're able to criticise Stern? Is it because, not for a personal reason, but for a commercial reason, because you receive it?
So I guess a bit of both. So as we read it, our client was really concerned about sort of mean, her boss did seem to decide against her and play quite a sensitive time of her life. And so I think that she wanted to have the option to be able to share her side of the story. And then she did also have that commercial incentive of she was going to get paid a substantial sum for discussing it in the reality TV show. So, but a bit of both, but I think both was of importance to her.
I think moving on to the strategy point now, I think the strategy we discussed was sort of a conceptual approach where we go to different sort of pivot points. So the first pivot point was that Mr. Stern was still working at the company, and clearly that came up quite quickly that he wasn't, and so we were sort of able to continue going along that similar path.
However, if he had been working at the company, we would have very quickly had to jump down to discussing compensation rather than performance.
Were you satisfied that he was not working with the company as opposed to for the company?
So when we asked what the degree to which he was associated, they said that he was not formally involved with the company. And we asked for that statement to be without prejudice. So the degree to which Mr. Stern was involved with, I guess, Horizon, we did say we want this incorporated into the contract at least already.
I think we can go a little bit further and see that he wasn't involved in the day-to-day sort of nature of the company either, and so I think that in light of those two statements, I think he probably was sort of peripherally involved, but it seemed very sort of peripherally involved, and in light of our client's interests are sort of not crossing paths with him. I think that someone who's peripherally involved in a large consultancy company, it probably is possible to have that sort of proper separation, and particularly in the light of the fact that they're issuing a statement sort of to the effect
that they do not agree with what they don't agree with the
Were you satisfied with the amount of money that you seem to be receiving on this agreement?
Definitely. So what our client had asked for was a new scope of, she wanted between $65,000 and $75,000, and we managed to get her 76. And then also that was open to further payments in relation to the reality TV show, which they seemed to understand would benefit their company as well as our client.
and then also obviously she was also going to get a payment from the TV company as well. So her financial issues, I think, are very strange, especially in the light of the fact that her hourly wage before the sort of all-in quarter was about $32 an hour, and afterwards, by our calculations, it's roughly in the region of $116 an hour. So we've essentially negotiated for a 4 times raise in hourly wage, which I think, if any bloke did that, would be pretty stoked.
And I think to some degree that is why we decided that even though the consultancy agreement was outside sort of what she'd specifically asked us for, because it did sort of address all of the interests that she'd made clear to us, and the fact that there was considerable sum of money, and she'd said, these are the minimum terms I want, but we managed to get her considerably more than just the minimum on every other point.
And I think her interests were also sort of protected in the fact that if she decides that maybe that's not what she wants, she does want to go particularly back to being a PA, that's sort of right off first refusal of any other executive PA role to allow her to successfully transition back into that role. I do think we missed a point to an extent on sort of clarifying what the terms that would be, but I think within the scope of the time provided, it would be a little bit hard to both develop sort of the contract relating to the consultancy role and also the contract relating to the PA role. And so I think
that with what we were asked to do today, I think we would be happy to take that back to our client. So we would probably consider your interest.
From a strategic point of view, was it intentional that as the only woman in the negotiating team, you played the role of mother and baby over and over about the need for the mother to adapt? Or was that coincidental?
That's somewhat coincidental. I just, I guess maybe I really like kids, so.
All right, thank you. Okay, thank you.
That's a good number.
I think it's probably easier for us to leave if you leave. That's great. I'll start. I'll be short first. Thank you. It was a fabulous opportunity to hear you both speak, and really enjoyed very much the arguments that you put. So the feedback is by means of trying to find things to criticise as opposed to being particularly critical. But I think one of the first things that we all struggled with, was we couldn't quite match up some of the arguments with the instructions. And so we are a bit worried you might get sued for going outside of your instructions, particularly seeing that you had to have everything signed off by 4 o'clock, and there were still some things that were a little bit open at the end. Just some very quick comments. The Horizon team and the Ansley team. The Horizon team, I think you did a fabulous job of your preparation. I think coming in with documentation was really interesting and quite challenging to actually be presented straight off the bat with proposed documents. So I thought that was quite interesting. From a factual point of view, I think you could have done your non-disparagement clause better to have included Mr. Stern as an ex-person, things that you knew that he was an ex-person involved, and that was clearly an issue for these guys as to whether he was in or was not in. I think you conceded a little bit quickly on a couple of the points. I liked the way that the interaction worked. He was so nice to each other, it was almost nauseating. But I think that the style of actually being respectful, I think somebody pointed out that it was being informal, using first names, being relatively informal, using first names with your clients was good, because it actually broke the ice quickly and you only had 50 minutes to talk about it. So from that point of view, I thought it was a really good strategy. However, I do think you both conceded a bit quickly on some things, or you didn't actually quite nail where you were going. So I don't know about whether you guys actually got Mr. Stern quite nailed in terms of where he sat in the space and how important it was to talk about whether, we were worried that you might have actually misrepresented the position about his involvement or not. And I think that you almost got it when you tried to do a with prejudice piece at the end, but didn't actually quite nail it in getting it to the document. That's quite important. Nice style, nice flow. I'm going to let these guys talk.
I think a couple of general things to begin with. The use of an agenda was good, but it seemed to get front wind after about 5 minutes in for this particular forum, and to a certain extent moving forwards. I would encourage doing a little bit more exploration before you pin your agenda down. You're not going to know how you're going to move through all the issues at hand and prioritise the correct things and table the correct things to get the outcome your client is looking for, unless you know what you're going to be talking about. You need to know where your client's at, you need to know where the other client's at. You do the exploration from the get-go, or at least try and face the exploration so you know where everyone's standing, and then you can use that to set an agenda that will get your client what they want and make emphasis of what are the key critical points like at the end of the day. We've got a 4 p.m. deadline. You've got to let the Commission know by 4 p.m. is the trial going ahead tomorrow. And in the absence of that, you're all locked in showing up 9 a.m. tomorrow morning and incurring another day's worth of fees. Generally, the beginning I thought was very, very good, talking through a lot of points quite broadly and generally, albeit after establishing what the agenda was, clarifying where everyone was standing. It was all fine to about 14 minutes in, when both parties tore up their instructions and threw them in the air. And I get very, very concerned about that, because there are two things that are absolutely critical to being a lawyer. The first is you don't double with the trust account, and the second is that instructions are absolutely sacrosanct. And I appreciate that in an environment like this, there's always going to be a very fine line around creativity. You're looking for angles, you're looking for edges, you're trying to add value, you're trying to, more often than not in these kind of environments, work with the other party to create a path forward that benefits everyone. And the creativity from both sides was exceptional, and the adaptability from both sides was exceptional. You worked with each other, you created what was a very palatable, in a vacuum, option moving forward for everyone. However, both sides had very critical bits of information in their facts that spoke to strict instructions on discrete points. Creativity ends the moment your instructions say otherwise. And no matter what, you can take back the best outcomes you will find in the world, and you say, look at what we've got you. If it's not your instructions, your client can turn around and simply say, they weren't my instructions, what have you done? And that's a world of unpleasantness that no one ever wants to touch in their professional career. That said, if we table the instructions component, the options that were moved through, the creativity, the talking through everything, a lot of the explanation, dynamic between each teams was good, dynamic across the table was good. We got to a very interesting outcome. And I think a lot of the negotiation skills demonstrated today were very, very strong. But the one thing I can't step away from is that line of instructions. And in my mind, that's something that keeps me up at night, is the idea that you've accidentally breached instructions and just gone, nah, this is something I can sell to my client later.
I noticed that in your interests and priorities, as the first interest/priority, you wrote avoid a trial at all costs. And I think that's very interesting, and I'm not holding it against you or anything, but it's interesting that people think that avoiding a trial at all costs is an actual priority. I don't think it is. There seems to be a kind of view that which is very, because of the pressures on the judiciary, etc., that settling is always good. I don't agree at all. A good negotiation, which can't really be recreated in a hypothetical atmosphere for structural reasons that you just can't get over. A good negotiation is about settling, which is good, but settling for the right price. I remember when I was studying law, it was an IP lawyer from some firm came in and spoke with us in some lectures as a guest. And I remember him saying that, in all his years, in all the litigious matters he's ever done, he had settled every single matter. And he said that with some pride. And I remember thinking when I was sitting there, that can't be a good thing. Because just as a matter of probability, it can't be that you have properly valued your prospects in every single settlement. Maybe you have, but I just can't see that's the case. See, when people go to litigation and advance cause of action or advance defense, effectively what they're making is a financial investment. So going ahead with litigation and suing someone is a financial investment, usually, not always. You're not always looking for money necessarily, but it's usually a financial investment which has a particular value, which isn't all that different from, say, what Warren Buffett does with shares. It has a certain value. You can undersell it, you can oversell it. And one of the things that I don't particularly like about negotiation competitions, I like watching them, I don't particularly like participating in them, is that you can't really recreate the reality of your client's position, because you can't. Let's say, for example, you go into a negotiation competition. The other side come up with a proposal, and in your view, you have a strong enough course of action that their proposal is one that you should not accept. Well, in a negotiation competition, if you just say, no, we're not accepting that, you're going to be marked down, because that's just not good negotiation in the eyes of a negotiation competition. But in reality, you might be doing the best possible thing as a lawyer in all the circumstances. So it's a very difficult thing to judge in negotiation competition, and you have to look at, you can't compare it to what a real lawyer would do in the real world exactly. It's just structurally impossible to do that, because there may be circumstances where a lawyer is perfectly entitled and perfectly competent, in fact demonstrates their competence by just saying, no, I'm not accepting that, that's ridiculous. And will go to court, because it's a good value judgment to go to court. I wouldn't go to the other extreme. I remember I did a negotiation competition when I was in uni, and my friend suggested a strategy of writing a big 0 on a napkin and passing it over the table and saying, well, until you accept this, we're not going to settle. I thought that was a little bit extreme. I thought actually my comments about the perversity of these competitions in one respect actually demonstrate, I'm not just saying this because I just recently found out that Chris wrote the problem, but I thought it actually reflects how good this problem was because it was so well balanced. Because it's, when it's not balanced, you get really perverse competitions, but when you have really well balanced problems, then you can actually properly judge a negotiation competition. I thought it was a really nice problem because there were kind of 3 parties in a way, but a silent party and these blocking interests. It was really good. But you can go into those circumstances, and it's not always the case in reality that you have a position of relatively equal strength for whatever reason. Sometimes you have circumstances where one party is much stronger than the other, and usually that happens in 2 circumstances: when someone has a lot of money or when someone has no money. If you have no money, you're effectively untouchable, and if you don't care about bankruptcy, you're untouchable. There's no point in proceeding against that person. If you have a lot of money, then you can absorb the loss and you can afford litigation, and again, you don't care. A lawyer in that position who says, oh, let's try and settle this at all costs is, in my view, one that hasn't properly valued, just as Warren Buffett might say, and look, I don't really know anything about finance, but I suspect that Warren Buffett would say something like, you have to understand the business to be able to understand the share. Doing well in a negotiation is not just about the obvious things like how you speak, how conciliatory you are, etc. It's also about going in there with a really clear idea of what the value of your cause of action is and that sort of thing. And I say this not because it particularly reflects upon what's happened today, but I do think it's important for young practitioners to know the differences between a competition and real life. And one of the ironies is that I work at the bar, and one of the ironies is that we don't really get to do negotiations that much, not at all. I do a lot of mediations. I've gone through a flurry of mediations in the past couple of months, and things often settle. But a mediation is not like a negotiation because you have a mediator shuttling back and forth, and it's just horse trading. That's all it is. You have your 5 minutes together in the joint room, but after that it's just horse trading. It's just numbers. Where negotiations happen in reality are 5 minutes before you go into court, and that's really about it.
3:55 p.m. on the day before.
Yeah, that's right. So
Should have sat from
big zeros on them. So look, I thought you all did very well. I'd be very comfortable if any one of you were representing me or something. But I think it's just important to bear in mind those differences. Negotiation is not just about the manner. It's also about valuing your course of action, and not reaching a settlement can sometimes be a smarter decision than reaching a settlement at all costs.
Interesting point about the equivalence of the parties and actually thinking about what they have at stake. I think that's a really valuable point. I think you both teams actually got that in terms of what was important to their clients from that point of view.
One question we had, thinking about the conversation we were having on the table, was given the time limitation that we were all facing, and we had quite different proposals coming across the table in both directions, how would we manage to integrate or deal with these really different in quality proposals in such a limited time?
I think that's born out of preparation. It's very difficult to do in a competition context. In a real context, I think creativity, as Chris mentioned, really, in my view, is a very real part of very real negotiations. I said mediations and it's horse trading, but you shouldn't underestimate creative solutions. And I say that thinking about matters in mind that I've done earlier this year, which I can't talk about because of the confidentiality of it, but they really are, because you can think about your client's interests and you can say, well, why don't we structure something that way? And if you've prepared for that, prepared for every possible outcome, then you can get to those things very quickly. So in a way, rather than it's kind of like saying, well, rather than studying the thing in the exam because it's open book, study it beforehand so you're ready when you go in and you can just deal with the problem. Well, that's essentially what it is.
I think taking that point and building on what was said before regarding being willing to go to trial and not having to reach an outcome in these circumstances is when you do your exploration late, when you do your exploration early, and you suddenly figure out actually this isn't going to go anywhere. We can sit here all day and we can talk about various positions and various options, and you can come up with the most creative approaches and be as adaptable as you can, but you find that you can't quite create that final bridge without reaching instructions. You then have that question of, do we just have to put our hands up and walk away? What is the next option? And so, again, with your preparation, you walk in there knowing what you want, but also where you're going to start. And when you reach that point, you go, this is it. You can't force something that's not going to work. What's your next option? What's your plan B?
And nothing prevents you at any stage of that entire process, even when things get difficult and right at the end, nothing prevents you from continuing to be civil with your colleagues. And you're always civil, but nothing prevents you from being civil. If you say, look, I can't accept that proposal, you can do that in a civil way. There's nothing that should prevent you from being civil.
I suppose just a quick question, because so on our next we obviously had our instructions and there actually wasn't the case in this negotiation and stuff. We worked out at the end there was going to be an overlap. We were going to be able to potentially come to an agreement different to the one that we came to. But in the end, we were on the written instructions. We both had quite firm written instructions, but then also instructions outlining in our case that we weren't allowed to go to court. Is that the point where potentially you start considering breaching those initial instructions, or do you so when you've been told you cannot go to court but you also must do this thing, do you have to engage in that weighing exercise of what does my client want more to not go to court or the specific things that I've been asked for?
This is going to be one of those very difficult ones of driving a specific wedge between this being a negotiation competition and the real. Insofar as this goes, you need to make a bit of a judgment call, and you then need to make most of your reflection to go, this is why we're going to make that judgment call. In the real world, you will always have access to a client, and you will always be able to finalise those necessary instructions, even when you're turning on the dime with an hour left before your discontinuance needs to be final. But fundamentally, it's still going to be a judgment call. There needs to be a judgment call if you come back. And in all of the circumstances, again, your instructions are involved. It needs to be the best of whatever it is, and trying to comply in all of the possible circumstances.
Come back to one other comment that was made about timing. Of course, in a real world situation, my advice would be never leave the room until you've got the settlement deed finished and signed and the word's exactly right, because you can walk out and think you'll finish it tomorrow, and by overnight people will have completely changed their minds. Never do it.
Looking at the situation really narrowly, as a big company and of course not representing Mr. Stern, the trial somewhat isn't a massive public policy, but Yuri and I looked at the big picture of things, and once the public image gets out, if it was to cause financial issues, job losses, family issues from the job losses, Yuri and I look at the line of big things and huge implications that could come from the trial if that was to happen. Like I was saying. Does that make sense?
So
I think it's important to look at the big picture as well. So, for example,
under 127.1, the company's still going to get hit with the full force of the order, and with the joint executive reliable reporting order that's handed out to the individual unless they can discharge their exemption. And that's always US and risk. But in those circumstances, you still need to look at the big picture, and that's very appropriate. But there's always going to be a lot of risks to the trial.
Don't be too paternal. Don't be a hero. Don't assume that you know what your client's interests are. I think the best way to deal with that would be to, in practice context, to say, look, to discuss those things as much as possible so you have as good an understanding of your client's interests as possible, and then run with that. So I can understand where you're coming from. Look, I'm trying to protect my client and there's all these consequential things, but as much as possible, let them make that judgment and convey it to you. And that's just about experience. You appreciate all the concomitant
Yeah, it's
implications.
just a point we learned in maritime law to learn the other day. The laws are going on about how they're always can be worried about. He's made this decision and he realised this decision caused job losses and people to go bankrupt, and he was like really upset with them. And he's like, sometimes it's better to just try and come to an agreement. That's what he was saying. And that really kind of stuck with us, especially. So yeah, we definitely talk about that as well.
Just like everyone else, like I'm doing this whole segment, but I don't know how many of those people are finding it super important. So maybe if we would like go somewhere else and they can sort of go and carry on with their evening, I think it should be some sort of
Unless you guys think
No, I don't.
Yeah.
Well, I said a thing I wanted to say.
Yeah, I feel like you know, said.
Thank you guys so much for that.
Thanks, great, it's a great pleasure.
Yeah.
I hope you have a fabulous time. Thank you very much. Congratulations. Really well. That's great.